Welcome to Court TV Live. I'm Julie Grant. In this hour, we're talking about the big hearing set to happen tomorrow, the continuation of what's called a Daubert hearing in the case against Karen Read. And so if you were just listening to the last segment we did, a Daubert hearing is where a judge is the gatekeeper of what is reliable information in the way of expert testimony that the jury can receive and use in their decision making. And so one of these motions that has turned into a Daubert hearing before the court has to do with the defense witness they offered as an expert to say that John O'Keefe was bitten by a dog. The Commonwealth is trying to stop that expert's testimony from coming into the case, saying that this doctor is not a qualified expert and therefore should not be permitted under the law to give such an opinion. Here to help us break down this case and those opinions, I want to bring in Court TV crime and justice correspondent Matt Johnson, who was there throughout the duration of that trial. Welcome back.
Thank you.
And good
nice
morning.
You
too. Okay, so let's start a little bit with getting us up to speed, if you will. This hearing that is coming up tomorrow started already, didn't it?
Yeah, it started on December 12th, and that's what we're going to revisit during your special hour of coverage here. So basically, it comes down to Beverly Cannoni, the judge in this case, who will oversee the second trial beginning on April 1st of this year. That's when it's set to take place, and who will be allowed to testify on behalf of the defense. So right now, what the defense is pushing for is to bring back expert Dr. Marie Russell. She is critical to the defense because their claims in their conspiracy theory that John O'Keefe, the victim in all of this, was attacked by a dog within the house at 22 Fairview during this snowstorm in January of 2022. So what they are going to be talking about in this hearing and the continuation tomorrow, Dr. Marie Russell opined that John O'Keefe's injuries were caused in part by a dog attack. Now, she's a medical doctor, a former police officer, and an expert witness in California, Florida, Illinois, Arizona, and Washington State. But then under cross-examination, you're going to notice that Hank Brennan, the special prosecutor brought in for the second trial, brought out the fact that she never in the country has she ever testified as a dog bite expert. But here is her qualifications, according to her, as to why she should be allowed. Take a listen.
With regard to wounds, do you have any experience with dog-inflicted wounds on humans?
Much experience.
Approximately how many dog bite wounds did you observe and treat in the emergency department at LAC-USC?
So the main emergency department?
Yes.
Well, over the course of all those years, at least 500.
LAC-USC happens to be one of the biggest hospitals in the county of Los Angeles. It's actually the front of General Hospital. If any of our fans watch that program, that's the hospital that goes by. But Dr. Russell, so she's an interesting character, Julie, in all of this, because now the Daubert hearing wasn't held before the first trial because she was a surprise witness in a lot of sorts, because she wasn't originally on the witness list. She contacted the defense and said, I am an expert in this field and I should be allowed to testify on your behalf because I believe that this was a dog attack. We don't know if they had someone else lined up the first time around, but this is who was presented. And she was voir dired outside of the presence of the jury in the first trial. That was very short. Ultimately, she was allowed in.
And Matt, thank you for the reminder about her. Did she watch the trial and call them? Did it happen in the middle of the trial when she reached out?
I want to say yes.
Yeah.
I mean, that's a little bit of a gray area.
Yeah.
I'm not sure if that was really made clear, but it was definitely during, after the start of the trial where she contacted this defense team.
Got you. And we know this is very nuanced, these hearings, because as you noted, Hank Brennan has started the cross. It's going to continue tomorrow. And one of the things that was brought out was that this is the only case ever where she's been qualified and testified as a dog bite expert.
Right, but she's also testified to the fact that she has written opinion papers and other done research on dog bites, and a lot of that to do with her being a medical doctor in the ER setting. She said that she has also witnessed dog training and dog attacks in being a police officer for a short amount of time. So these are the reasons why she feels that she's qualified, but never in any of those states where she's qualified as a medical expert with opinion in trials has she ever testified about dog bites.
Gotcha. Matt Johnson, thank you so much for this. Tomorrow it continues.
It does.
We'll be watching it. Thank you very much. And we want to show you some of this testimony that may or may not come back into the next trial. Here's a clip of Dr. Marie Russell, and she's talking about what she says are cuts from a dog attack.
Were you able to confidently come to any conclusions or opinions about the nature of the injuries suffered by John O'Keefe, specifically as they relate to John O'Keefe's right arm?
Yes.
What is your opinion and conclusion concerning those injuries?
Those injuries appear to be consistent with an animal attack.
Can you be more specific in terms of the type of animal, or are you relegated to simply an animal attack?
Well, they are consistent with a large dog attack. There's a combination of both what I consider bite wounds and scratch wounds on the arm. There were also some puncture wounds in that shirt.
And are the
So I'm sorry, puncture wounds in the shirt?
Puncture holes in the shirt.
and on what do you base the opinion that the injuries are consistent with dog bite or scratch marks?
Well, the patterns. There are several patterns of parallel wounds that appear to be superficial scratches that could have been caused by nails or could have been caused by teeth. There are different angles on the arm and different locations on the arm, and but they're generally oriented in a specific direction. And there's also an area, the distal forearm, which is close to the wrist, which shows what I believe is an arch area of teeth marks.
And what's the significance of the arch area?
Well, so the arch would be the front area of the jaw of the animal, or the dog in this case, where the teeth tend to be close together and curved. There's a curved pattern to the configuration of the teeth.
So could you tell me again what your opinion is and to what degree you hold that opinion?
Yes. These injuries in the arm are, my opinion is that they are the result of animal bites or scratches.
And do you know what kind of animal?
Oh, yes, most likely dog, large dog. And I'm very very sure to, what's the word I want? Medical certainty. Very
All right,
high degree of medical certainty.
Reasonable degree of medical certainty.
Yes, definitely.
Oh, you saw the judge correcting her on the standard of admissibility for this kind of testimony. So remember, with a hung jury in a mistrial declaration, it's a clean slate the second time around. It's a brand new trial, and we've got a brand new, incredible prosecutor leading the charge who is fighting to keep this out. As he noted with some of the recent testimony, there has been no authority who's ever designated this woman to be an expert in dog bites. Let's bring in our guests and talk about this hearing and what we can expect tomorrow when it resumes. Judge Carol Erskine and attorney Tommy Pope on the program. Great to have you both. Judge, so in this Daubert hearing, tell us please, what is the judge looking for as she listens to another direct and another cross of Dr. Marie Russell?
Yeah, good morning, Julie. I think what she's looking for is what was earlier stated, and that is there are two factors. I mean, you're looking at a Daubert hearing in Massachusetts. It's called a Daubert-Lanigan hearing because the case in Massachusetts is Lanigan. And essentially what you're looking at is relevance and whether or not the testimony that's going to be offered to the trier of fact is relevant to the facts of the case. I don't think that's in dispute in this case because the position is that those injuries occurred from a car. Her position is that there was an alternative method for how those injuries occurred. But I think basically the judge is looking at reliability. And as stated before, you're looking at the reliability factors, the methodology, the underlying manner in which the expert is relying on. And in this case, I think she's pretty clear, both in the December 12th hearing and maybe in the first hearing, that she's relying on pattern recognition as the methodology. And so I think the judge is going to look at her testimony from December 12th as she looked at the pattern of those injuries along with the holes that she's saying came from a bite from a tooth mark. So I think that's one of the major issues is what is the methodology here, and is there enough reliability in that methodology to allow the testimony in?
Judge, thank you for all of that. This is really helpful. We saw in the start of this hearing, which was in December, you know, it's a shame it couldn't have just gone over 2 days back to back, because it's hard to even recall what was said, but we're going to be playing it on court TV. You'll see it before we get to tomorrow. But there was just a little bit of cross from the prosecutor. And so, Tommy Pope, when we think about how this is the prosecution's motion, it is them who were saying this expert's testimony isn't reliable, it's untrustworthy. What are some of the things we can expect the Commonwealth to be cross-examining this doctor on when things resume tomorrow?
I think they've got to focus right now on the standard that the judge just explained to you and not use your bullets of. I feel like just from what you presented to us today, I feel like in my courtroom, South Carolina, I think there was a good chance she would be allowed in, particularly as a defense witness. She's a doctor. She has experience in methodology. I mean, we have dog bite mark identification, you know. And so everything I see, my mind was just piecing it together. I would be saving my best material for cross-examination because I think she's coming in. I think in abundance of caution, they're going to defer to the defense side. And so the fact that she called, kind of interjected herself in the case is one. I'd be interested if it was post-mortem or antemortem, or can you tell, and maybe they've already done that. I think, they're not saying this is the cause of death, the marks themselves. And so, I mean, I think there's plenty of room for cross to kind of debunk her or at least soften it. But you just got to be careful, because if she's a qualified doctor, I mean, pointing out that she's never been an expert on this subject matter in any other case in the country can be good for the jury. It doesn't really matter on a pure admissibility standpoint. There's always a first time that you're admitted, but I think it can be used to good effect in front of a jury to discredit this witness.
Tommy, appreciate all of that. This is really helpful. You know, and the other thing that just kind of taking a step back and seeing the forest through the trees, we know that no canine DNA was present on the victim's body, on Officer John O'Keefe's body. And so that also, I would think, is going to be a big factor here. I'm being told we have to hit a break, so we'll continue talking about that and so much more in a couple of minutes. Tommy Pope, Judge Carol Erskine are staying with us for the hour. Want you to do the same. When we come back, we've got a clip from Jennifer McCabe. This Jennifer McCabe herself talking about the search that was made at 6:24 a.m.
This week.
Join us each morning to get trial ready for the day's proceedings. Plus, deeper dives into true crime stories with our daily spotlight.
Opening statements with Julie Grant. Weekday mornings at 8/7 Central on Court TV.
I'm Vinny Politan. Welcome to Closing Arguments.
What's happening here?
It's unreal. Let me show you exactly what happened.
Closing Arguments with Vinny Politan. Tonight at 8/7 Central. Only on Court TV.
Welcome back to Court TV Live. I'm Julie Grant. We're looking ahead to defendant Karen Read's Daubert hearing continuing tomorrow. Her defense is now her defense has also received another motion in the meantime from the prosecution, who is trying to bar a key defense expert. This because they say this expert's testimony has been unequivocally debunked. So we're talking about the defense team's digital expert that they brought in. His name is Richard Green, and he introduced evidence that supports the defense theory. They're claiming that Jennifer McCabe Googled how long to die in cold at 2:27 a.m. Take a listen.
We found a Google search that happened. First of all, the search was how long to die in cold, and it happened at or before 2:27 a.m.
In what state did you find that artifact?
Yeah, so the specific artifact, or it comes from a record, and the record number on this is 4028, I believe, and it was in a deleted state.
Now, in a motion filed just last week, prosecutors are saying that analysis by that defense analyst has, quote, been refuted not only by the Commonwealth's independent experts, but by the company Cellbrite itself, the company that has that data extraction software program. So the company is saying it too. The state saying it all proves that Jennifer McCabe Googled the search when she said she did at 6:24 a.m. at the direction of Karen Read when they found John O'Keefe's body in the snow. So now let's take a listen back to what John O'Keefe's friend, Jennifer McCabe, said about that search.
We were in the back of the police cruiser. Karen was sitting in there. I kind of scooched myself in. Miss Roberts came over. Karen grabbed our hands. She asked us to pray. She looked at her hands and she had blood. She asked us if she could have gotten her period. We told her no, that was John's blood. Then she said, what if he's dead? Promise me you'll take care of the kids. Someone's going to take care of the kids. Then we prayed. Then at the end, they were moving John. And at that point, Karen told Kerry, go over, look, is he dead? Is he dead? Is he dead? Over and over. And Kerry said, I'll go over and check on him. And she was yelling, are they working on him? And then at that point, she grabbed my hands and she said, Google hypothermia, Google how long it takes to die in the cold. And so I had my phone out and it was cold and my hands were frozen and I have MS, and I took my phone out while she was screaming and shaking my arm, and I attempted to Google how long does it take to die in the cold.
And when you conducted that search, that was at the defendant's request on scene sometime after 6 a.m. on that day, correct?
Yes.
You recall whether or not that came up as far as your search in Google? Is it something that you typed once or more than once?
I believe I did it multiple times because as I was typing it, I don't know what else was coming up. She was screaming. My hands were shaking.
And do you recall anything as far as what the search results were, or did you click on anything, or did you get an answer to the question the defendant had posed to you?
I don't even think I got an answer because as I kept Googling and she kept yelling, and then they were moving John, and the next thing I knew we were kind of moving because she wanted to see if they were working on him.
And so you were moving along with the defendant over towards where Mr. O'Keefe had gone to the back of the ambulance?
Yes, we kind of just moved to see what was going on.
When you moved over, what did you see then?
They were just putting him in the back of the ambulance.
Now, after Mr. O'Keefe was put into the back of the ambulance, where did you go then? What did you do?
At that point, different police officers, I believe, were arriving, and they were asking questions about what happened.
And did you speak to those officers?
I did, yes.
And at that point, did you know what happened?
No, to be honest, it was like I was there, but everything was just going on, and I was completely just in a state of shock and disbelief.
Now, in this motion, it also points out something that I think was probably missed by a lot of people during the trial, that the defense expert even conceded in his testimony that the company, the software company, Cellbrite, modified their software based on his misinterpretation. So what's the judge going to do? Should this information reach the jury? The Commonwealth says no, that allowing inadmissible evidence to reach the jury would be a huge mistake and create prejudice. We're going to talk about it more on the other side of the break when we hear some testimony from someone from Cellbrite. One of their experts was in the case as well, saying the same thing, that the search happened exactly when Jennifer McCabe said it did. Welcome back to Court TV Live. I'm Julie Grant. So when things pick back up tomorrow in Massachusetts for Karen Read regarding whether or not the defense's witness is going to be allowed to give her opinion on what she claims was a dog bite, there could be another motion that comes up, the one we're talking about this morning, about Jennifer McCabe's Google search. The prosecution wants to keep out the defense's digital expert because they say that his opinion has been debunked by their independent experts and by someone who works for the company Cellbrite, whose software that expert used. So let's take a listen to that person now. His name is Ian Whiffen. Again, he works for Cellbrite. Listen to what he explains about how the search occurred.
The two searches of interest, the how long to die in the kickd and how long to die in the cold, didn't exist within the history DB at all.
Now, sir, if I could ask you just a little bit now about the browser state DB. Again, can you explain to the jury sort of what that is and how it, if at all, it plays a role in your analysis?
Yep. So initially, pre and including iOS 14, the browser state database would show all tabs that you currently had opened. So as soon as I go into my browser and open a new tab, a record is created. It includes information such as the time that I opened the tab or the time I last viewed the tab, the current URL which is being displayed within that tab. It shows information whether it's in private browsing mode or not. So in that kind of case, in iOS 14 and below, we're able to see current private browsing records and subsequently recover deleted ones. But in iOS 15, things changed. The record was no longer written as soon as the tab was opened. It was only opened when the tab was closed. The record was only created when the tab was closed. That meant that our ability to recover that kind of history was significantly lower. It means that it no longer makes use of the private browsing field because now private browsing records simply are never written to that database. So now we can only really see a list of all of the tabs that have been closed, not which are currently open.
Now, with regard to the browser state DB, is there something referred to as a last viewed timestamp?
There is, yes. That's one of the fields within the database.
And can you explain specifically with relation to that field, sort of what kind of information is kept there and what it means?
Yeah, so from my research based on this, that timestamp relates to the time that the tab took focus. So that's either when the user creates the brand new tab, when they switch between tabs and bring a tab back into focus, when they close a tab, which automatically brings one of the background tabs into focus, or if Safari has been completely closed and reopened, that essentially acts like almost a new tab, and the timestamp gets updated at that point.
Can you explain how an earlier timestamp could be associated from, say, tab is open, something is done, tab is closed, tab is reopened, something else is done, how that earlier timestamp could then be associated data-wise with the subsequent search?
I think
opening it.
I think I followed that. Okay, so if, for example, at 12 p.m. I create a new tab, I can do a search for whatever I want, and at that point, if I close the tab, then the record that gets created will show that I opened a tab at 12 p.m. and I did a search. Excuse me. However, if I open the same tab at 12 p.m., do a search, close it, like completely close down Safari and reopen Safari, that would also update the same timestamp to show that I'd opened it up again. What I meant to say at that point is that if I create a 12 o'clock tab, minimize Safari, I can leave it for several hours, for several days, for several weeks. The time difference is not really important. When I come back to it and open up Safari again from a background state, the timestamp is not updated. So it will still show 12 p.m. today, and it will show whatever my most recent navigational event is. So I can search for something in 3 weeks' time using the same tab I opened today, and the timestamp will show today's time.
Okay, so Cellbrite, the company he works for, has updated its software because of what they say was a misinterpretation in this case by the defense expert. So how about that? So now when they do the analysis again, it's noted in this Commonwealth motion, when they analyze Jennifer McCabe's phone again, it says unequivocally that the search happened at 6:23, 6:24 a.m. when they found John O'Keefe. So should that expert be allowed to still give that opinion that he thinks it's 2:27 a.m.? Let's bring in our guests and discuss that. Still with me, Judge Carol Erskine and attorney Tommy Pope. Judge, what do you think? Should the court allow that expert to come in and give that same opinion?
Well, I think, I'm not sure why the defense would want that expert, and given what's happened afterwards, and that he would likely be debunked. I think, basically, I think their position on that is really collapsing. So I'm not sure, and I also think that there certainly might be potential under Daubert Lanigan that she won't allow it in based on the fact that it's hard to support the methodology that he indicated he used in the first trial has now been debunked. So I'm not sure. I'm like the doctor with the dog bite who I think should be qualified as an expert and was qualified as an expert the first time. I think there is the potential for a finding, and a finding that I think that could be upheld. I don't think the judge would be, and the standard is abuse of discretion. I really don't think that anyone could find she would abuse her discretion if she disqualified the witness from testifying. And as I said, I'm just not sure why they would want to. I mean, why not just leave it to, I don't know why the prosecution is pursuing it. Why not just leave it to cross-examination?
Judge, brilliant analysis. That's a really great point you made about why would the defense even want him if this has been debunked, all of the independent experts and the company's employee is saying that's wrong. What the defense experts saying is wrong, and we even changed our software to make sure nobody can be wrong about this again because it's created such a mess. Right, Judge, why would they want him? Tommy Pope, your thoughts on that? Why might they still want to call Richard Green?
Well, the defense job's a whole different thing. They're looking for reasonable doubt with one juror. And so anything you can put in there, you put the kitchen sink if you need to. So even though they could be debunked or crossed, because if you notice, I was thinking when the state's expert, the guy from the business was testifying, it was still a little tough and confusing. I think it lends itself well to an in-court demonstration, ideally with a PowerPoint so your phone doesn't mess up, but to show them, everybody knows the tabs, but they might not call them tabs. Everybody understands the habit of opening one up and leaving it and coming back later. So I think it's explainable, but I think that part needs to be tightened up. But unlike the previous witness, I agree with the judge. I think this is a different circumstance. I think the defense expert in front of the judge on the stand, thoroughly cross-examined, he's not going to have answers for it. And, one of the thresholds and the reason you have these hearings is to prevent confusion with the jury or misleading information. And I think this lands right in that spot. And so, you know, it's kind of a strategy thing. It would be neat to debunk them in front of a jury, but I think it's more junk in the system that their prosecutor wouldn't want. You'd want to keep it tight. So hopefully they'll have that opportunity, cross-examine this witness. That witness will fold, and this won't come in.
Mm-hmm. Right, Tommy. I'm with you. This is a very well-written motion. Filed by the new lead prosecutor, Hank Brennan, who's tremendous. And he uses words like this, allowing this inadmissible opinion in would infect the jury and create prejudice. And so some very strong language. And he even calls out Karen Read for promoting this, what he calls promoting this false narrative, cites an interview with a reporter named Gretchen Voss, where she's pushing forward this narrative that it happened at 227. So it'll be interesting if this comes up tomorrow. Great analysis from you both. Stand by, please. When we come back, we'll hear from that expert, Richard Green, the one who gave the now debunked opinion about 227 a.m. We'll hear from him when we return. Welcome back to Court TV Live. Now, as promised, you're going to hear this straight from the horse's mouth. So we're talking about witness Richard Green, brought in as a digital expert by the attorneys defending Karen Read, to say that Jennifer McCabe's Google search occurred at 2:27 a.m. rather than 6:23 and 6:24 a.m. Let's listen to some of his testimony here. You're going to see the direct and the cross.
We found a Google search that happened. First of all, the search was "How long to die in cold," and it happened at or before 2:27 a.m.
All right. Where was that search found?
Sure. So the artifact on that was called a Safari Suspended Tabs artifact, and there's a database associated with that called the Browser DB database, and in a company file, which is by the same name but ends in WAL, which stands for Write Ahead Log. And the Write Ahead Log is where the data first gets written to, and then at certain points, that data then gets committed and written to the main database.
All right. So that, if I'm correct, that browserstate.db/wall file, that's a temporary file, right?
It's temporary by nature, but it's not. That's not it's integral. It's part of the way the SQLite functions. So it's not like a throwaway file. It's part of the way the whole system works.
And is it helpful to you when evaluating artifacts?
Certainly, yeah. Just by nature of it, we'll find a lot of the newest artifacts in that wall file.
Now, how do you determine the timing in terms of the timestamp on the browserstate.db wall file?
Sure. So the wall file has different rows and columns. You can kind of think of it as an Excel spreadsheet. And in this one particular column, had it was a time column. That'd be the nature of the data going into it. And this the heading on this particular one was last viewed time.
Okay. Regarding that Google search for HOS long, and I say HOS, HOS long to die in cold, found in the browser state DB wall file, what was the date and time for that artifact?
Sure. So that's recorded in what's called an Apicocoa time, and it's actually the number of seconds since January 1st, 2001. So you end up with this large number, and that gets converted to present to us something that's human readable, and then you have to apply the offset for the local. So once you do all those calculations, that's where we get the January 29th, 2022 at 2:27 in the morning.
The specific, do you remember the number of seconds after?
I believe it's 40 seconds.
2:27, 40 seconds.
Yeah.
Okay. And in what state did you find that artifact?
Yeah, so the specific artifact, or it comes from a record, and the record number on this is 4028, I believe, and it was in a deleted state.
Okay. Now, what would you normally expect to find along with the artifact, sir?
So you'd have the date and time, the URL, which the way the URL presents itself, we know that it's a Google search, but you also see a history of other places that tab has been.
And with this particular artifact, did you learn the full internet history of websites related to that record?
No, that wasn't possible. We were only able to get the one website. I would say.
And I'm sorry.
I'm sorry. Go ahead.
I interrupted you. Sorry.
Well, no. So we definitely get the one artifact, the Google search, and we have the time related to it, but we do not know everywhere else that tab had been.
You've done further testing, and that's shown that you were wrong, correct?
That is correct.
Are you aware that Cellebrite has had to modify their software based on misinterpretation of data, as you've done in this case?
Yes, with the asterisk, they updated one of two programs.
Nothing further.
Okay, and that right there was the concession I was telling you about, but a lot of people missed it because there wasn't a lot of inflection from the prosecutor. Other advocates probably would have made a bigger deal about that. Let's bring in attorney Tommy Pope and Judge Carol Erskine to talk about this. Tommy, that could have been a moment. That could have been a huge moment for Adam Lally and Stu. And I got to be honest with you, I didn't realize this until I read Hank Brennan's motion last week, that they conceded that Cellebrite updated the software because of this guy's error. What do you think?
You know, when you're in front of a jury, that's particularly on cross, and I know you've taught cross-examination, that's when you want to be, and you're the one testifying. And so that was the time to be up close in front of the jury, and no matter what the answer was, your question was what was important. And so, again, whether we end up, as the judge said last section, if we end up with this guy in court and we cross, I think there's tremendous opportunity to discredit it, but it's kind of a red herring that if you can keep it out through these hearings, that's the better way to go and a cleaner way for the case.
I appreciate it, Tommy. And Judge Erskine, I want to go back to a point that you made earlier that I really want to underscore how different these pending motions are, right? This one over data that the company itself is saying was misinterpreted versus the opinion of one doctor saying dog bite and another doctor saying no way it's a dog bite. How do you think the judge is going to handle these two particular inquiries?
Yeah, I think it would be shocking to me if she disallowed the testimony of the doctor. She's highly qualified. And I think, to use Tommy's language, it's quite a red herring to say that Roshi hasn't testified before a court on dog bites. I mean, to me, so what? I heard lots of testimony on sex abuse cases and termination of parental rights cases where people testified regarding sexual abuse. They were child abuse experts, but may not have testified on sexual abuse. There was no way it was going to disallow hearing that opinion. I think what underlies both of these, as you ask, is that there's only one person in that room that has a Sixth Amendment right to a fair trial and, to use the language of the Sixth Amendment, compulsory process to call their own witnesses. And it's not Hank Brennan, it's not Mr. Yannetti, it's not the judge, it's not the people standing outside the court wearing pink shirts and holding signs. There's only one person with constitutional rights in that case to call witnesses. So it's a risky business for a judge to disallow a witness. And in this particular case, someone like the doctor who's more than qualified and has testimony that's relevant. So I think that underlies it all. I mean, Tommy talked about South Carolina. I point out the case of Holmes versus South Carolina, where the court said it's unfair to allow the prosecution to call its expert witness, but not the defense. It was based on a statute there. So that's, I think, the way I'm thinking.
Judge. And you are a constitutional law professor. For anybody who doesn't know that, you're that as well as being a retired judge and attorney. We've got to leave it there for now, but such brilliant analysis from you both. Thank you for weighing in. Judge Carol Erskine, Tommy Pope, thank you both so much.